Hello, America. I'm Sam Gold. Smith and Amar. Those are two cases that have come down from the California State Supreme Court. They're very important cases because they have to do with what injured workers' attorneys can and cannot do for their clients. With me tonight is Thurman Martin, Jr. Good evening, Thurman.
Hello, Sam.
Maybe you can explain why these Smith and Amar cases are so important to injured workers and their attorneys.
Sam, Smith and Amar are very important because one of the largest issues in California workers' compensation is the ability for injured workers to get medical treatment. As you know, the system is supposed to provide for wage loss when you're off of work. It's supposed to provide for permanent disability should you have permanent damage, impairment, or disability from the injury, and medical treatment as long as you need it to cure and or relieve the effects of the industrial injury. So we have a UR system in California now called utilization review, where based on a treatment guideline, which is basically a flow chart for treatment of every different type of injury, is used to be compared against what your doctor requests on your behalf for medical treatment. If the treatment the doctor requests doesn't fit the flow chart as laid out in the American College of Occupational and Environmental Medicine book by a group of doctors in Washington State, we call it ACOM. If it doesn't match that treatment guideline, it's denied. Well, then what does an injured worker do at that point? In the old days, the treating physician made a request and had a presumption, and unless the insurance company could prove that treating physician wrong or incorrect factually or otherwise, the treatment basically got done. Now with utilization review, the UR doctor can deny the treatment, and then the injured worker is left with either getting a rebuttal report from their treating doctor, which is very difficult to do because treating doctors don't really get paid for that. It's a lot of paperwork. It's a lot of work. A lot of them don't know how to rebut using other guidelines that are peer-reviewed and nationally recognized. So it makes it difficult. But they can either get a report rebutting and go straight to trial, what we call an expedited hearing, which is an emergency hearing that's supposed to be set within 30 days on important issues like benefits or treatment.
Are they ever really?
At the Oakland board right now, it usually takes around 3 to 4 months to get an expedited hearing. In San Jose, for some reason, they are often set before you ever get served or have time, your 10 days to respond to a request for hearing by either side. So
the law really doesn't sometimes respond to the caseload.
It does not respond to the caseload, and it's becoming more difficult, and we'll talk about that. But back to Smith and Amar quickly, this utilization review process, they can either, an injured worker can get a rebuttal report, go to trial, or they can elect, according to the Sandhagen case, another California Supreme Court case earlier this year, injured worker can elect to go to a panel doctor to resolve the treatment dispute. Many times the insurance company wants to go to a panel doctor to resolve the treatment dispute, but their real motivation isn't to resolve the treatment dispute. It's to lock that injured worker into a panel doctor that they can run to with every problem to trump whatever the treating physician requests.
Sort of like an AME.
A forced AME, in a sense. Agreed medical examiner, AME, usually means you do something by agreement. Coercion and agreement aren't the same thing in my book. But at any rate, that's how the process works. For injured workers with attorneys, there's a new labor code section, 4607, and that labor code section has been interpreted to mean that any time an award of benefits is terminated or denied by an insurance company and then it's enforced, the attorney is entitled to a fee. So injured workers attorneys use this code section that when treatment was challenged and then denied, a treatment request was made and then denied, go to court, win a hearing, and then request fees under 4607 for the work performed to enforce the applicant's award of medical treatment. The California Supreme Court in Smith and Amar said basically that they don't agree that 4607 should be used for constructive denials of awards or terminations of awards by simple denials of treatment. That's not denying the award, they say, which means the settlement itself. And so attorney fees shouldn't be paid to attorneys for doing this work. Well, why does that matter to an injured worker? Well, if an injured worker is requesting that his or her attorney go to court and spend a day in a trial, maybe spend another half day total filing paperwork and writing to the doctor and getting the evidence together. So an injured worker wants their attorney to spend 2 days on something, maybe more, to run down to court on their behalf. Basically, under this ruling, that work is done for free.
So they're saying that you should do it for free.
Well, it's a little more complicated. The California Supreme Court is saying we already have a provision to get fees for these types of situations, and it's called Labor Code Section 5814.5. Labor Code Section 5814 is what we call a penalty section, where if an injured worker prevails on an issue and the treatment, the money, the benefit was unreasonably delayed and it can be proven, then the insurance company has to pay a penalty. The penalty goes to the applicant, and then an hourly fee for the number of hours that it took to get to the penalty can be paid to the injured worker's attorney. The California Supreme Court says the answer lies in getting the treatment and then getting the penalty, not in getting a fee under 4607. That's problematic in a couple ways. It's problematic because penalties used to be 10% of the entire class of benefits that it came from. So if we're talking about medical treatment, and there was $100,000 worth of medical treatment in the case thus far, it would be a $10,000 penalty. Well, then an insurance company would pay attention about denying your 12 visits of physical therapy or your acupuncture or your next injection.
Yeah, but they chewed that up in 2004.
Correct.
With SB 899.
Exactly right.
And now it has absolutely no teeth whatsoever.
Exactly right. And the reason it has no teeth is because I just described it used to be 10% of the entire class and gave the example. Under Arnold, Governor Schwarzenegger's new law in California, many people will tell you that the Democratic legislature passed Senate Bill 899, and therefore it's not Arnold's reform, but they did it with a gun at their head.
Half of the Democrats didn't even know what they were voting on. Jackie Goldberg, God bless her, Assemblywoman from Southern California, she's the only one that read it. She said, I ain't voting for it.
They had a gun to their head because the governor was enormously popular. And
Not anymore.
He was threatened. No, he's thank God.
Yeah.
But he was pushing for an initiative or threatening one if he didn't get his way. In addition to that, we now know that the Democratic legislature was being pushed by their leader, John Burton at the time, who was Senate Pro Tem, to make a deal and let basically the Chamber of Commerce and big business have their way with the comp system and get their 50-year wish list in exchange for providing health benefits for all working Californians. It was called SB2.
What about injured workers? 100 years ago they came up with this benefits delivery system, and over that 100 years, injured workers benefits under that system have been hacked away and hacked away and hacked away to the point where it doesn't even resemble what they came up with over 100 years ago, yet the insurance industry and everything they got, they have lost absolutely nothing whatsoever. Ain't fair, is it?
It's not fair. And Sam,
it's all about money.
Not only have injured workers lost, but insurance companies have gained enormously. And anyway, back to the point, the Democratic legislature was told to go ahead and okay this comp deform because on the table was health benefits for all working Californians. That did not work out. Senator Burton did not get his legacy, and in the wake of that, the injured worker was severely harmed. Going back to, so I call it Arnold's reform for those reasons. It was the governor's reform, no matter what kind of spin the governor puts on it, and that's why the governor wants to hold on to these changes to the comp system so strongly, because that's the only success he has to point to in his 2 terms as governor of California. He's been a disaster. We all know it. The state is in severe financial crisis. He can't lead his own party. He can't lead the Democratic Party, and he's borrowed. He can't. That's his own party. He can't lead them, and he can't lead the other party, which is the Democratic Party.
Thank God I didn't vote for him.
He can't get anything done, and the state is in severe crisis. He's borrowed already several times, and we really can't borrow anymore. So we have huge problems. So that's why I call it his reform. Now, in his classic doublespeak, Orwellian doublespeak, which Arnold's the master of, the governor claimed that he was going to increase penalties, Sam. He was going to make them bigger. They were going to be 25% instead of 10%. But the governor limited the penalties to 25% of only the delayed treatment, not 10% of the entire class, or 25% of the entire class. So if we're talking about 10 visits of physical therapy at maybe $100 or $50 a visit, we're talking now about the penalty is only 25% of that amount if you get it. Well, practically, why does that matter and what does that mean? Well, if your attorney goes into the courtroom and the attorney wants to have a trial, which means a half day probably in the courtroom, then the judge has to write a decision within 90 days.
Right.
Because the judge is being tracked statistically for all these things. That's another one of the governor's deforms. He put Mr. Starr in charge of the judges in California, and Mr. Starr has enacted a system where there are statistics on judges' performance, caseload, how quick they get their decisions out, how many times they support applicants, how many times they support defendants, and they track all of these things. So the judge is looking at a half-day trial in his courtroom or her courtroom. They're looking at having to get a decision out in 90 days, a possible appeal by either party, having to write a response to that appeal because they're compelled by law to do so. It's called opinion on decision, so that the Workers' Compensation Appeals Board in San Francisco can then look at all the information. Well, if a judge sees you coming in and your attorney's sitting there wanting to have a penalty trial over 10 visits of physical therapy on this hand, and then the judge weighs all this time and effort that the judge is going to have to put into this issue, and it weighs out like this for the judge is going to do everything in his or her power to force the parties to resolve the issue right there at the table. So the Supreme Court in its Pollyanna world, sitting up on some bench somewhere and not having to actually practice law in the trenches anymore, can say easily in Smith and Amar that technically there's already provision for attorney's fees for denials of treatment under 5814.5 if an attorney gets a penalty under 5814. But the problem with that is in a practical real world, when you go into that courtroom and you want a 25% penalty on $200 worth of treatment, which is very important to your client, but the judge is looking about $50 penalty and all of this work, the judge isn't going to allow that to go forward, and they're going to do everything they can to coerce the insurance to make some undisclosed payment for some, or disclosed but uncharacterized payment for some amount, nominal amount, to make the problem go away. The problem with that then is, if the issue isn't pushed to trial and there isn't an award, does the attorney get fees then under 5814.5?
Well, if you work and you have to create this paperwork to place before the court to bring these issues to light, then you should get paid.
That would be the applicant attorney's
that makes
position.
sense. I mean, the defense attorney, he's running a taxi meter.
He is running a taxi meter, and he doesn't care, or she doesn't care usually, because they're getting paid by the hour. They're billing their client, and the clients, the insurance companies, usually spend far more in fighting these things than it would to be to pay for the actual treatment. But nonetheless, these things are causing problems then, because if your attorney can't get paid for the work, oftentimes we're talking about 2 or 3 days worth of work.
He's not going to take the case.
Times, most applicant attorneys have anywhere between 200 and 400 clients. If you're doing 2 days worth of work for free times 250 clients, say, there's not enough minutes in a week left to get any work done, to go to trial on other cases, to talk to your clients, to correspond with defendants. So it puts applicant attorneys in a serious conflict with their client. They want to represent their client's needs and push their client's rights to the fullest extent of the law. But at the same time, on a practical level, they're now being asked to work under the law for free. I usually push pretty hard for those types of fees, and I know for a fact that I get a lot of resistance from judges about, Mr. Martin, why are you so unreasonable? Mr. Martin, why do you want to push this all the way? Why won't you just settle? It's because, Judge, if I don't push on those issues and enforce this person's treatment, I'm not doing my duty to them. And then once I've done that, I need to get paid for my time. So the judges don't like that answer, even though they understand it, because they're just thinking about how much time they're going to have to expend on the issue, and they see it as a frivolous issue. So it's a huge issue in California, and the Smith and Amar decisions are huge decisions that impact the injured worker's ability to get their attorney to act on their behalf. There's some other things going on in California right now. There was a bill that was vetoed by the governor that was sponsored by Sally Lieber, an assemblywoman in the state.
She's now been termed out.
Do you know anything about that bill?
Yeah, well, I think you're talking about AB 2969, and that had to do with the issue of utilization review, which is probably one of the top reasons why you end up having to go back into court on behalf of your clients, because the utilization review process is usually flawed. Let me throw an example at you. And we had a gentleman on here about a couple of years ago, I think it was in episode 10, who's been in the system for, my God, 30 years. He's had 6, 7 back surgeries. And he was dealing with an insurance company who bought the insurance company whom his company was covered by. You got to understand, this was like 30 years ago. And he's had 6 surgeries. He needed a 7th. He's in so much pain that he wanted to have them cut a nerve in his back that would stop the pain. And he was fighting and fighting and fighting, and they kept stonewalling him and stonewalling him. And I think for a time there, he was almost suicidal. You know, I talked to him in my volunteer position as the director of the National Organization of Injured Workers. And what about a case like that, where this gentleman had an award that said to cure and relieve? And that was an award that was won for him by the late Lowell Erola. Arola and Ringgold. This is 30 years ago.
Yeah, unfortunately, one of the more insidious aspects of the reform is it's retroactive to all dates of injury. And so the new rules about utilization review and denial of treatment apply to even that old case. I think what AB 2969 mostly talked about was Ms. Lieber, on behalf of several doctors' organizations, unions, and labor organizations, were trying to get the utilization reviewed doctors to have a license to practice medicine in California. They could have a license to practice in any other state they wanted, but they additionally had to have a license in California because if you're getting treatment for a work injury that occurred in California and you're a Californian and you're in the California workers' compensation system, it only seemed fair that the doctor would have to be then licensed in California and be subject to the American or the California Board of Medicine and its rules, requirements, training. But the governor vetoed this bill. It's been said that the governor vetoed the bill because he didn't like the language or because he thought the provisions were already in the law and we didn't need extra provisions. But the real reason the governor vetoed this bill was because the American Insurance Association, the AIA, was against the bill, and basically that's who told him to veto the bill, and so he did exactly what they wanted. This is a governor who claimed when he got elected that he couldn't be bought because he had his own money. He was the dominator. He was from Hollywood, and he didn't need to be influenced by big business. But those are the words. And if we look at what somebody does as opposed to what they say, his actual actions show that he is a slave to big business, that he is continually cited on behalf of big business for campaign contributions or for his power base looking towards his next election. He does have aspirations to run for United States Senate or Assembly or the House. And if he does that, he's going to need financial backing. So in reality, the governor has basically defrauded the people of California again, and he's taken a lot of money from insurance companies, in this case, the American Insurance Association, and vetoed this bill. And this bill has to do with utilization review, and it has to do with injured workers' ability to get treatment, because if the doctor had to be licensed in California and had to take pain management training as is required in California, and had to be subject to the California Board of Medicine, then maybe that doctor would have a different outcome or decision when he's reviewing the treating doctor's request for treatment.
Well, Thurman, I'm proud to tell you that that bill is back in the Assembly, this time sponsored by Assemblyperson Fong. It has passed the Assembly, and it is headed for the Senate. And this time, maybe some of those Republicans who are voting the partisan line can do the right thing and enact this important law, because what's happening here is these doctors are responsible to nobody. What if they stop a treatment that causes the death of an injured worker? Who's responsible? They're going to claim, well, this is no fault. Well, it ain't our fault. But who's responsible? These doctors who do this, who do this utilization review, have to be responsible to somebody. As you recall, in my own case, I had a knee injury, settled that knee injury. My doctor, who is a doctor who his reputation is beyond reproach, he is the only orthopedist on the Blue Ribbon Workers' Compensation Appeals Board doctor committee. He's the only orthopedist on there. And he said, I need the physical therapy. Now, unbeknownst to them, I paid for 3 sessions of physical therapy out of my own pocket. and it certainly helped me. So who are these people to look at a bunch of papers without even examining me or checking me out to tell me that physical therapy is not going to help me when I have proven that it will?
Unfortunately, that's the law in California, Sam, and I think
Time to change it.
It is time to change it, and on that note, it's important for injured workers at home to understand that this is the time to write to their assembly person or their state senator or even the governor and tell them that they have an interest in this issue and that they want their local representative to vote for this issue. Unfortunately, the only thing that people in Sacramento who represent us understand is money and power and also votes. And if you don't put pressure on them and they don't feel like their position is at risk, then they won't take action if they don't have to, and they won't upset big business if they don't have to. So it's imperative that injured workers, those who love injured workers, those who know injured workers, get involved in this issue as quickly as possible. Some other developments that are going on in the state right now is we're still waiting for some decisions that were about the ACOM guidelines, which is our disability guidelines, or I'm sorry, the AMA guidelines, our disability guidelines, about Alvarez and Guzman. Those decisions were taken up sua sponte, so to speak, by the board itself, even though they were en banc, to reconsider decisions they made that were unanimous decisions, signed by everybody, after they got a letter from the head of the DIR at the behest of the governor asking them to reverse these decisions. They took these things up. The briefing timetable has passed, and we are looking at a situation where we hopefully will get a decision sometime in the next month, sometime in the next 60 days. That decision would allow us out of the AMA guidelines, and if that happened, that may loosen up some of the hard lines on treatment. If it's considered that the books are no longer absolute with regard to disability, maybe they will no longer be absolute with regard to treatment. We'll see what happens.
Thurman, thanks again for coming on here and telling us about this important decision. I know it affects a lot of folks, and you're taking the time to explain this in a fashion that they understand. Certainly helps a lot of people. I get calls every day saying, "God bless you guys. Thank you for explaining this to me. My lawyer won't." Well, that's why we're here. We're here to help you, to explain these things to you. Thank you, Thurman.
Thank you.
Hope to see you again. Come back soon.